Good morning, members. We have a quorum. May I call to order the meeting of the Bills Committee on Employment Amendment Bill 2014. This is our 7th meeting. Can we invite the administration to come in? Good morning. Good morning to you. Let me tell you about our meeting arrangement. Last time, that is at the last meeting, we have done clause by clause up to section 15J. And between the last meeting and today, we have received a few papers, and today we only have 2 substantive sections to deal with. I'd like to deal with the technical papers and also the clause-by-clause examination, and then we will come back to discuss the amendments proposed by members, including those from Dr. Helena Wong, and also Mr. Lee Choi-yen actually has given notice that he is going to move amendments. If we cannot complete our discussion within these 2 hours, I hope maybe on or in the week of the 21st of July we can have another meeting, and the clerk will be asking you for your availability. Maybe we need another meeting to deal with CSAs. Before we go back to clause-by-clause examination, let us take a look at 2 papers. The first one, CB bracket 2, 1911, 13 to 14 bracket 01. And that is a letter written by our legal advisor to the administration. Another paper dated the 4th of July 2014, that's paper CB bracket 2, 1986, 13 to 14 bracket 01. The administration, can you walk us through those papers briefly? Certainly, Chairman. May I defer to Mr. Lam of the Department of Justice to take you through the paper written by the legal advisor. And then with regard to 15L, I will take you through that. Okay, Mr. Lam, please. Thank you, Chairman. In response to the advice of the legal advisor payment. No, I think we are talking about the paper written on the 24th of June 2014. And I think you should address paper 1986-01. Are you on that paper? Yes, indeed, Chairman. All right, then. The definition of paternity leave pay. We think the proposed definition in its present form is sufficiently clear, and we don't think we need to amend it to include any particular clause number. And of course, it's not as simple as that. Sorry, Mr. Lam, can I ask you a question? Why is it that in other ordinances you did include a clause number? Why don't you do that here? Is it that you have a different style of drafting now? Or are you saying that there is absolutely no need to include a clause number? If it is a simple way for the readers to do a cross-referencing, then that is meaningful. But if we just add in part 3A, well, actually, the pay during paternity leave is not just in one clause. There are different clauses on the eligibility, the amount of pay, and also exemptions. If we include all these clauses, then it's not good referencing. And in fact, the definition is not like a dictionary entry. It just gives the definition of the term. So if it is not as simple as just including one clause reference, and also without it, there is no difference made to its meaning, so we prefer not to include the clause reference. Okay, continue please. Second part. The term child 嬰兒, should we also include the Chinese term 嬰兒? Actually, child is defined to mean anyone under the age of 15 years. Now, of course, 嬰兒 is also below 15 years. However, in part 3a, we actually do not have to rely on the definition of child to indicate a newborn. We all know what a newborn is. Since it doesn't have to rely on the definition of child to supplement its meaning, we therefore will not add the Chinese term 嬰兒 to the definition of child. Yes? Why, I don't get it. If everybody knows the term 嬰兒, which is infant or baby, why do you want to call it child? Why don't you use a term which everybody understands and which does not cause confusion? Of course, we can guess by the context that child should mean baby. But why don't we go for clarity and absolute clarity in law drafting? Mr. Lam? We believe we need to indicate the relationship between child and father. No, I think some members are saying when you interpret child as sometimes 兒童, sometimes 嬰兒, and yet the term in English is always the same term child. However, you seem to render it into two different terms in Chinese depending on the context, and that may cause confusion. If the reader only knows Chinese or English, now of course if you are bilingual, you might understand what the ordinance is about. Mr. Lam, can you explain further? Maybe the Bureau can explain. Ms. Luke. Here we use the term child, and I'd like to draw members' attention to clause 15I2. And we refer to the birth registration ordinance. And since we mention the birth registration ordinance, and since in that ordinance the term in English is child and in Chinese 嬰兒, which means baby. Between this ordinance and the birth registration ordinance, there should be cross-referencing because this has to do with the certificate of birth. So we need some internal consistency here.
Ms. Helena Wang, in our clauses, after years of change, sometimes the Chinese and English names are not completely equivalent. If we have to align them, it will be really challenging. I understand that there's history in our laws that you are trying to continue with the existing wordings in the law. So at least should you make a note, or can you clarify it by including a note in the law to say that child refers to both 兒童 and 嬰兒? We are talking about two different ordinances. In the employment ordinance, it's an ordinance with a long history, and in section 2, bracket 1 of the employment ordinance, we have a definition for child, and in this amendment bill, it's used in conjunction with the birth registration ordinance. If we have different words like infants and babies, these words had never appeared in the original ordinance. And if we introduce these words, they might cause further confusion. So this is something we must consider. Can we invite the legal advisor to give his view, her view on this issue? The definition of child, in Chinese, it refers to 兒童. In our new clauses, we refer to 嬰兒 as well, without affecting the meaning and to clarify the clauses. Can we add an extra line of description under child to include 嬰兒 or infants as well? There's no contradiction because for when we refer to children under 15 years of age, but this will make the clause clearer. You have to look at the big picture of the entire amendment bill. You cannot just look at one particular line. In Part 3A, the term child is linked to the birth and death registration ordinance. So when you look at the term child, it carries two meanings. Can Ms. Look further elaborate on the definition of child and why you cannot expand the definition of child as per the comments of our legal advisor? You can retain the original definition of child, but after the semicolon, you can refer to the particular part of the employment ordinance, and you can refer to the other meaning of the term child. And this would not affect the general interpretation of the word child. And in Part 3A, can you consider introducing a line? I'm not saying that you have to change the entire meaning of child, but you might draw another definition of the word. Yes, we understand the views of the chairman. Thank you very much. You may continue, Mr. Lam. Next, on Section 15D, brackets 1C, and it stipulates the conditions in which a male employee is entitled to the benefits. And in Section 15D, some clauses apply to the employees. And if the we ask the employers to follow all the stipulations. And when we look at Section 15D, they are not all applicable. And the expression, all the requirements serve to achieve this purpose. Any comments from the legal advisor? Anything to follow up? You may continue. And under 15D, brackets 3, let me go back a little bit. Under Section 15D, 3B, in the English, it stipulates when employees are entitled to paternity leave. And in Chinese it reads the 10 weeks from the date in which the baby was born. And we draw the line on the day when the baby was actually born. And in the Chinese, it says from the day the baby was born, and it's very clear. So there is no difference in the Chinese and English descriptions. I have a different understanding. I'm not sure whether the day the baby was born, that particular day, is included. So you need to be very clear whether the day when the baby is born is included, or are we looking at looking at the next day? Well, our understanding is that when we said 10 weeks from the inclusive of the actual date of the delivery of the child, there's no way we would exclude that first day. We understand the DOJ's view, but when the reader looks at the ordinance, he might look at both the Chinese and English, and the period ends 10 weeks from the inclusive of the actual date of delivery of the child. It's very clear in the English that the date of delivery is included. If such description is missing in the Chinese, it might lead to doubts for the reader. And in the existing EO, we do have similar descriptions in the English. For maternity leave, we have similar descriptions. And in Chinese, there's an extra description to specifically include the start and end dates. We agree that there should be consistency between the new legislation and existing legislations. I agree with the legal advisor's view. We should add a line of description in brackets to specifically include the start and end dates. It will make things clearer. Ms. Helena Wang. So are those 10 weeks? Do those 10 weeks begin on the day in which on the day of the delivery? Do we include the delivery date? Yes, the difference is only 1 day, right? Have we made this very clear in our amendment bill? Over the course of delivery, is the male employee entitled to paternity leaves? Some people, some women might take a long time to deliver. So before the actual delivery, are the male employees entitled to PL? The period actually begins 4 weeks before the expected date of delivery. Does it include 4 weeks before the date of delivery? The employee is entitled to PL 4 weeks before delivery and 10 weeks after the actual delivery. Mr. Lam, please continue. 15G. Under section 15G, brackets B, the expression is the same as 15D. And the expression all the requirements is appropriate in our opinion. So hopefully you can consider our recommendation, which is to add a bracketed expression to clarify the clauses. We would consider the views of the chairman. Next, section 15F brackets 1. And in the English, it says paternity leave is in addition to rest days, holidays, and annual leave to which an employee is entitled under the ordinance. And under the ordinance, the employee is entitled to different benefits apart from rest days, holidays, and annual leave. He is also entitled to paternity leave. In English, the expression is in addition to. In Chinese, it says the subject is the employee, and the employee can enjoy rest days, holidays, and annual leave, as well as PL. So under this stipulation, it means that the employee is entitled to PL in addition to the rest days, holidays, and annual leave. The meaning is exactly the same as English, although the mode of expression is a little bit different. It's not a word-for-word correspondence. The key is the focus of the expression. If the Chinese text doesn't correspond to the English, the DOJ said in the Chinese the subject is employee, and the employee is entitled to rest days, holidays, and annual leave, as well as PL. Our emphasis should be on paternity leave, and this clause should emphasize the fact that PL is not to be overlapped with other existing types of holidays. It's completely independent. But looking at this Chinese stipulation, it seems to suggest that PL is something in addition to the rest days, holidays, and annual leave. So the focus has shifted. So this is the main problem. Any comments from members? The legal advisor mentioned a problem with the Chinese translation. When we look at the English, the subject is the paternity leave, and it should also be the subject of the Chinese version. Although it might be technically challenging for the Chinese translation. But we have to be very concise and accurate. So can you come up with a solution to solve this problem?
Please continue, Mr. Lam. Okay, let me address the section 15L and the views of the legal advisor. The legal advisor is talking about the offense provisions for not providing PL or PL pay, and we allow the employers to have a reasonable defense. However, that reasonable defense does not attend to maternity leave. The legal advisor is asking why the situation is different for maternity and paternity leave. Our view is maternity leave is not the same as PL because maternity leave has to do with an employee who is pregnant, and the employer will know exactly which employee is pregnant and the employment relationship is clear. But in terms of PL, the employer may not know the person who is pregnant. The male employee may just be any other employee, and the difference is just that the employer is informed by the male employee that his partner may be delivering very soon, but then the employer has no knowledge of that woman. And also, under maternity leave, we will empower the employee that as long as enough notice is given, she will be entitled to the leave for delivery of the baby, and the employer cannot say no. But then paternity leave is something entirely new in Hong Kong, and if an employee has chosen some dates to be on leave, and if the employer cannot veto it, then it will be a totally new arrangement which is now absent from the entire EO. Therefore, if in such a situation, if PL is not given or PL pay is not given by the employer, we should allow the employer to go to the court to advance reasonable defense. In fact, with regard to holiday, annual leave, and sickness allowance or statutory holidays, if the employer doesn't provide such leave or allowance, he is still allowed the defense of reasonable excuse for consideration by the court. Mr. Tan Ka-Pyu. Thank you, Chairman. Actually, we have visited this point 3-4 times. We believe you are flouting the principle of equality, and the EOC has also commented on this, and I have asked the employee representatives at the LAB. I am sure that this has not been discussed at the LAB, and the vacuum is now being interpreted by the administration. I, of course, think that this is problematic, but I don't want this to drag on for a few years at the Labour Advisory Board because people will then be denied PL in the interim. So can't you now try to remedy the situation by making this proposal if indeed there is dismissal? The employer should compensate the dismissed employee the pay for the 3 days PL which has been denied the employee because we should have similar compensation as we have for maternity leave, and in fact this is a compromise already. And then you have said that the protection may not be compatible with the 3 days PL. Administration. Well, talking about employee compensation, we have already explained before why we think that in such a situation this is not the same as maternity leave. We have heard all the views of the committee. After completion of scrutiny, we will take another look at the bill. Mr. Tan Ka-Pyu, I know you have written in, and later on we'll have some time to discuss your letter dated the 7th of July. I don't know whether you are going to move any CSAs, but we'll allow some time for your letter to be discussed so that such discussion will be minuted. Legal advisor. Nothing from you? Now let us continue to do clause-by-clause examination of the bill, and then we can attend to other matters, including papers from the administrations and CSAs proposed by members. Is it that Ms. Luke, no, Ms. Zhang, you will help us scrutinize the provisions in the bill? I think we are now at 15K. Payment of paternity leave pay. You can start. Thank you, Chairman. 15K states the period within which PL pay has to be given, and also if the PL pay has already paid in advance, then in specified conditions, the employer can deduct the PL pay already given from the salary of the employee. Clause 1, the employee under Section 15I or 15J must provide the necessary documents. 15I is to state that the baby was born in Hong Kong, and 15J for a baby born outside Hong Kong. And this has to do with the document required. And then subclause 2 and subclause 3 have to do with the taking of paternity leave. Now, whether documentation should be submitted before or after PL, and when the employer should pay the PL pay. Subclause 2 says that if an employee has taken PL on a day, let us call it leave day, and provided the employer with the requisite document on or before the leave day, the employer must pay him the paternity leave in respect of the leave day not later than the day on which he is next paid his wages after the leave day, or if he has ceased to be employed by the employer not later than 7 days after the cessation. Clause 3 says if the employee provides the employer with the requisite document after the leave day, the employer must pay him the maternity leave pay in respect of the leave day not later than the day on which he is next paid his wages after the document is provided, or if he has ceased to be employed by the employer not later than 7 days after the document is provided. Please stop here. Ms. Chang. Questions, members? On the first 3 clauses under 15K. Well, I have a question. When you say leave day, if you are paid a monthly salary, should it be the day that usually on which usually the salary is paid, or would there be a specific stipulation under the EO which day is the leave day, or actually the pay day? Let me give you an example. If the employee works in March and usually the pay day is in April, but he takes, for example, 1 PL leave day in March and he submits the document in May, and then in April, and then in May he takes the other 2 leave days. Since in May he has given documents for his first leave day in March, then he should be paid that day's salary in May, and then for the 2 days in May, the pay should be paid in June. The payday would depend on the stipulation in the employment contract. Ms. Zhang, you can continue. Subclause 4. It says where the employer has paid the employee the paternity leave pay in respect of the leave day before the requisite document is provided, the employer may deduct from his wages an amount equivalent to the paternity leave pay if A. He fails to provide the employer with the requisite document within 3 months after the first day on which the paternity leave is taken, or he has ceased to be employed by the employer and fails to provide the employer with the requisite document before the cessation. Good, no questions? Subclause 5. It says, if after the deduction, the employee provides the employer with the requisite document in accordance with Section 15I bracket 4 or 15J bracket 3, the employer must pay him the paternity leave pay in respect of the leave day again, not later than the day on which he is next paid his wages after the document is provided, or if he has ceased to be employed by the employer, not later than 7 days after the document is provided. In fact, the arrangement is the same as subclause 3. Please give me a moment to read through it, Ms. Zhang.
委員冇問題啊。
Members, any questions? If not, please carry on. Yes, Alan? Chairman, I can't think this through. Just now, Ms. Zhang gave us an example. It is a monthly paid employee. He takes 1 day PL in March. He puts in the requisite document in April. And according to Ms. Zhang, in May, the PL pay should be given. But if he is paid monthly, does it mean that he has been deducted that 1 day PL wages in March? How does this work? Okay, you take PL in March, you have worked 1 day less, so you have 1 day's wages deducted. And then you put in the requisite document in April, and then in May, you are paid that 1 day's wages in March. Is that right? So first a deduction, and then secondly, the employer will pay up. Who will answer the question? Ms. Zhang, that is correct. Your understanding is correct, this member. But if the employer doesn't first deduct the salary, then this is possible, even without the requisite document. Then my question is, bracket 4, is that about this particular situation that we have just talked about? Are we talking about that example? In other words, if there is no deduction in March, then subclause 4 will apply. Yes. Okay then. In fact, if salary is paid through auto-pay, I think many companies just would not take away 1 day's salary, and they would not pay 4/5 of the salary. Not even your chamber will do that, right? 15L, offense. Subclause 1, an employer must grant an employee paternity leave to which the employee is entitled and pay an employee paternity leave pay to which the employee is entitled in accordance with Section 15K. Subclause 2, an employer who, without reasonable excuse, contravenes subsection 1, commits an offense and is liable on conviction to a fine at level 5, meaning $50,000. Are there imprisonment terms? No. There is just a fine of $50,000 at most. Do we have any case law to let us know what is meant by reasonable excuse, Ms. Zhang? I think it depends on the context of each case. For example, the requisite documents submitted by the employee may not satisfy the employer, who may have doubts about those papers. And also, maybe in terms of salary payment, maybe during a period something happens and the entire company pays wages or salaries late. Those may be reasonable excuses, but as to whether these are acceptable, it is up to the court, and also the arguments and evidence advanced by the two parties. Thank you, Mr. Lee Chuck-yan. You have a question. Well, yes, I'd like to ask a question for the sake of comparison. A fine at level 5, how does this compare with similar offenses in EO, say, for example, for maternity leave and sick leave? Well, I know the fine is much higher for pay in arrears, but I'd like to know about this because we are of the view that paternity leave should be equated with maternity leave. Can you give me the information? Ms. Jan, well, in fact, I also like to ask about pay in arrears. In which provision do we see an imprisonment term in the EO? You mean pay in arrears? Under Section 23, Section 25, and Section 32, these have to do with non-payment of wages. These would carry imprisonment terms. I think also unreasonable dismissal, said Mr. Lee Chuck-yan. The member mentioned the levels of fines. This is compared to the non-giving of maternity leave pay and non-payment of annual leave pay and also non-payment of statutory holiday pay. This is comparable to those.
Any other questions from members? Mr. Alan Leung. Well, perhaps I'm not in good shape this morning, but I still don't understand. I asked a question about clause 15K brackets for let's say I'm on a monthly wage and I took a day of PL in March and I filed the application in April. And as the chairman said, my employer didn't deduct my 4/5 of my pay for 1 day. Let's say if my employer didn't deduct 1/5 of my salary for that day, right? No, according to this ordinance, a whole day's salary was deducted. Yes, I understand, but let's say my employer is very kind and they didn't deduct any salary from March. After I filed my application in April, let's say if the employer is going to deduct my salary later, how does it work if my employer has to deduct that 1/5 of my salary according to the law? If the PL pay given by the employer is higher than stipulated by the law according to Section 32 brackets 2 brackets E of the EO, it stipulates the overpayment of salary to the employee, and in such cases, the employer is entitled to make deductions. If the employer pays the employee as usual during the month in which the employee is entitled to PL, there's no way they can get the money back, right? I understand that a lot of employers would be rather generous. Let's say if the employer pays full salary in March for the month of PL, the employer is not entitled to make deductions. Well, in fact, they can if they want. If the employer only pays 4/5 of the salary according to the law, they are entitled to deduct the corresponding amounts from the employee later, right? If the employee doesn't submit the relevant documents within 3 months after delivery, the employer is entitled to deduct that amount. I understand, but in actual operations, if an employer paid full salary to an employee in March due to PL, can the employer still get back that extra 1/5 of the salary paid? If the employer pays anything to the employee beyond the stipulations of the law, and whether the employer will make deductions later on depends on the agreement between employer and employee. So for the amendment bill, there is no stipulation on the situation I mentioned, right? Yes, okay. Any other questions? If not, let's move on to the consequential amendments. We can go over them very quickly, and then we will move on to the other papers and CSAs. Please, Ms. Chang. Clause 7 to 16 stipulate the relevant amendments to the EO due to PL, with the exception of clause 9, brackets 3. There is a correction to the Chinese text, and on the clause 7, section 32.0 amended award of terminal payments, and in the English it's page 17, in the Chinese page 20, and after section 32.0 bracket 3 bracket D, an additional bracket DA is introduced, any paternity leave pay payable under Part 3A, and there's a corresponding description in the English version as well. Please continue. Clause 8, amendment of section 32 of EO on restriction on deduction from wages, and after section 32 bracket 2 bracket G, we have added brackets GA, deductions permitted by section 15K brackets 4. In 15K brackets 4, what kind of permissions are stipulated? According to 15K brackets 4, if before the employee provides the relevant documents, the employee has already provided PL pay. If the employee doesn't provide the right documents within 3 months after delivery or before termination of contracts, if these documents are not provided within this time frame, the employer can deduct it, the PL pay already given out earlier. Please continue. Clause 9. Amendment of Section 33 of EO on sickness allowance. And subclause 1 under Section 33 brackets 4 BAAA brackets small letter A. In the marked the text, it's on page 21, and for the Chinese version, page 26. The English version, page 26. And after maternity leave, we have added a day of paternity leave, and it's the same in both the Chinese and English versions. I have a question for DOJ. The cross-references are rather odd. Why do we have to have a clause named Section 33 brackets 4 BAAA? It's very confusing. There are a lot of cases like that in the EO. Long-term speaking, can we try to tidy up these glitches and make it easier for the reader? Every time we have an amendment, in between, if we have any additions in between the clauses, we have to add them between the clauses. That's why we might have some strange codes like that. And there's no plan to reorganize these codes, because it would affect the cross-references in with all other ordinances. So in the later we will have like 6 or 7 alphabets. Ms. Sidho. And they have the editorial rights to reorganize these figures and letters under the law publication ordinance. Why don't you reorganize those numbers instead of introducing codes like 4BAA? You have an editorial right according to the law publication ordinance. We have no plans to make amendments to the EO. Well, my question was, why didn't you do it? I'm not asking whether you have plans to do it. Mr. Hui, perhaps Mr. Hui can help. If the law is to be amended, you have to give instructions to the DOJ. Do you have plans to improve the EO? There are lots of clauses inserted, and it makes life very difficult for the reader. Can Mr. Hui respond to this question? We have a lot of amendments under the employment ordinance. It's one of the most frequently amended, in fact, and that's why we see very long codes like that. On the amendment of the PL bill, we will not amend the entire EO because it takes a lot of effort. And later on, we will hold meetings with the DOJ on how to tackle this issue. This has nothing to do with the policy bureaus. It should be the job of the DOJ, of the drafting team. And the drafting team has made a lot of mistakes and typos these days, and they might not have time to reorganize these codes. And this is not their fault, but I'm just saying that they haven't. This is something they should do. Perhaps you should ask for more resources from the finance secretary to work on these things. Ms. Chang, can we continue, please? And in clause 2, 33, amendment of section 33, brackets 4BAAA, brackets small letter a, after maternity leave, we will add a day of paternity leave. And And subsection subclause 3, section 33, bracket 6, bracket A, repeal the hospital, nursing homes, and maternity homes registration ordinance, and to be replaced by hospital, nursing homes, and maternity homes registration ordinance, and the words care homes is amended to nursing home, and the registration ordinance is amended as well. And there's also an amendment to section 35 after section 35 brackets 1 brackets A, after maternity leave. The clause a day of paternity leave is added, and subclause 2 under section 35 brackets 2A brackets 1 after paternity leave is added, and for section 41 amended rate of holiday pay for section 41 brackets 1 bracket A after maternity leave, a day of paternity leave is added, and for section 41 brackets 3 A1 after maternity leave, paternity leave is added, and for section 41 AA amended annual leave, and under section 41 AA brackets 10, holidays and maternity leave is repealed to be replaced by the expression holidays, maternity leave, and paternity leave. In the English text, because of grammar and the position of the comma, holidays and maternity leave are crossed out to be replaced by holidays, maternity leave, and paternity leave. And this change is consistent with the Chinese version. You may continue. Clause 13, amendment of section 41C on rates of annual leave pay. Under section 41C brackets 1 brackets A, after maternity leave, the expression a day of paternity leave is added. And for section 41C brackets 3 brackets A brackets 1, after maternity leave, the expression paternity leave is added. For section 43 amended on payment of holiday pay, etc., in event of bankruptcy, etc., under section 43, the expression maternity leave pay is repealed and to be replaced by maternity leave pay, paternity leave pay. And for clause 15, amendment of section 43 and interpretation of part 4b, section 43 and 1, definition of specified entitlement after paragraph C. The expression bracket CA, any paternity leave pay payable under part 3A is added. And for section 43 and 1, definition of specified entitlement, paragraph 1, after maternity leave, the expression paternity leave is added. And for section 43 and 1, definition of specified entitlement, paragraph 1, after bracket C, the expression bracket CA is added. For section 43 and 1, definition of specified entitlement, paragraph JI after C. And for amendment of 49A, after maternity leave, the expression paternity leave is added.
Legal advisor, thank you, Chairman. I'd like the Bureau to clarify something with regard to the documents to be preserved by the employer vis-a-vis paternity leave. Do they include requisite documents to be supplied by the employees, for example, birth certificate and other relevant papers? Ms. Zhang. Thank you, Chairman. Under 49A, it says that the employer would have to keep the wage record of employees and also the personal record of each employee, including the date of first appointment, ID number, and the post title, etc. Because the employee is entitled to the PL after the requisite documents have been vetted by the employer. Therefore, under 49 capital A, there is no stipulation as to what records or papers about the employees should be kept by the employer. Thank you. Any other questions, members? If not, we can go into part 3. Ms. Zhang, please continue. Thank you, Chairman. Part 3 is on amendment to the minimum wage ordinance. Under Section 6, wages, after G, we add bracket GA. And the relevant amendment has to do with Section 32 bracket G bracket 2 bracket G of the EO, and we are going to add in paragraph GA. Can you remind us what that paragraph is going to be about? Yes, Chairman. To amend Section 32 of the EO is to effect the restrictions on the deduction of wages. As I said, according to 15 capital K bracket 4, actually, before the requisite documents are supplied, the employer might have already paid the PL pay. And if the employee does not submit the requisite documents within the specified period, then within 3 months after the first day of the PL, and the wages can be deducted. And Section 32 has to do with restrictions on wages, and that is we just add in the provisions as contained in 15 capital K bracket 4. Okay, if members have no questions, we have completed clause by clause examination of the bill. Members who have come in late, I have already said that we might need another meeting in July depending on how the progress is when we discuss other papers and whether members would like to move major CSAs. Members, if you have no other technical issues to raise under clause by clause examination, we'll go into another part of the meeting, and that is CSAs submitted or papers submitted by the administration. The first paper to look at, CB bracket 2, 1986, 13 to 14, bracket 02. Mr. Hui, can you walk us through that paper, please? Thank you, Chairman. The Bills Committee put forward a view before, and that is relating to the calculation of the daily average of the wages. It seems that the term used is different from the employment ordinance, that it is different for holidays or annual leave. For PL, we call it average daily wages. But in other parts of the EO, we use the term daily average of the wages. The Bills Committee is of the view that perhaps we should align all the other sections with the PL term, average daily wages. We have vetted the relevant sections and are of the view that whether we call it average daily wages or daily average of the wages, in fact, the calculation is clear and there will be no confusion caused. We believe the law will still be clear, so there is no intention to cover the said amendments in the bill. But Mr. Hui, yes, I understand you have this preference, but later on, are you going to use average daily wages, or can the DOJ comment and tell us whether you will indeed prefer average daily wages in your future drafting work? Maybe the DOJ can comment. Average daily wages is a term which is familiar to readers. We are inclined that in the same context we are going to use this term from now on. Ms. Sitho, Chairman, these are different terms. And if there is an argument and people have to look up documents for reference, well, actually, as written in this paper, we cannot see the intention as orally given just now. You said that there will be no confusion caused. Why don't you just say clearly that actually the two terms mean the same thing? Why don't you state clearly and specifically that even if the DOJ has adopted a new term, the meaning is totally the same so that there will be no confusion in the future. DOJ, this is a supplementary paper. I think before we have already said in another paper that the two meanings are the same. Well, if that's the case, why don't you write your papers in the same way? Maybe the DOJ, you should remind me of that previous paper that you mentioned. Give me the serial number so we can dig it up. Or else I would ask you to write another paper and state clearly that you're of the view that actually the two constructions have the same legal meaning, at least in the eyes of the DOJ. The clerk, can you look up that serial number for the benefit of members? Okay, let's carry on. The point is about the long title of the bill. Many members have questions about that, Mr. Hui. Chairman, some members asked us about the long title, saying that it's too long. But we have looked at it again and are of the view that it has accurately reflected the content of the bill and also the legal policy behind the bill, so we don't think it should be amended. I think many members have questions about this. Mr. Lee Cheuk-yen. In fact, the long titles of bills have all become longer. But let me clarify something. My understanding is even if you have a very long title, it doesn't mean you can limit the scope of the bill. I think this is your view, but I don't know whether the legal advisor thinks the same. I think you want to limit the scope of the bill, so it's difficult for us to make amendments. In the long title, you say 3 days, and therefore we cannot do anything about it. I think you have bad intentions before writing such long titles, because then we cannot change it to 7 days. But I need to clarify 2 points. Number one, legally speaking, is it that long titles are there really to limit the scope of the bill? In other words, we cannot venture outside the long title. Certainly, we need to set a scope for any bills, and the scope of the bill is very clear here, and that is to provide PL. But then it should not be limiting PL to 3 days. So the first question is it that if you have a long title, you can limit the scope of the bill basing on your bad intentions? And number two, this doesn't only have to do with this bill, and I'm really talking about the entire drafting style of the DOJ. Is it your style of drafting that you are writing long titles, or is it the instruction of the policy bureaus? So who is doing it, the DOJ or the bureaus? If you want such long titles, why don't you write the entire bill into the long title? Mr. Hui first, and then Mr. Lam. Let me explain. If you talk about long titles, if you read the Chinese, it's just 2.5 lines. It's not that long. In the long title, we mention the days of PL and also the amount of PL pay. In fact, in all our policy papers, we have stated the same policy. Read our papers submitted to the Manpower Panel and other consultation papers. We have stated that the policy intent is to provide a 3 days PL leave at 4/5 salary. This is the policy. Mr. Lam, any supplement from you? Who decides how long the long titles should be? Are you instructed by the bureaus how to write that long title? Certainly, the long title of bills are drafted by the Law Drafting Division. But what are the considerations behind drafting the long title? Actually, on the 16th of July 2012, we responded to that question at the AJLS panel. I don't know whether members would like me to repeat what we said in that paper. We'll walk us through that briefly. We are considering 3 things in drafting the long title. Number one, it must abide by ROP 53 of the Legislative Council, and 2, it should be able to include the entire scope of the content of the bill, and number 3, it should be sufficiently clear so people are clear about the subject of the bill. So what kind of content there is in the long title depends on the content of the bill itself. As to whether the long title of this bill contains too many details, or whether there is an intention to debar members from moving amendments. Well, that is not our intention. The two main points are PL and PL pay. And if we think we can assist readers in understanding the bill by reading the long title, then we will draft the long title that way. And of course, when you talk about PN pay, the first thing readers would like to know is how many days of PL there will be and how much pay there will be. And therefore, we believe this will be helpful to readers. Well, before I ask members for questions, Mr. Lam, I think maybe you have overdone it. The Chinese can be as simple as to say amend the employment ordinance to provide for a male employee's entitlement to paternity leave, full stop. Mr. Hui says there will be annual reviews. If that's the case, then you may have to come back with an amendment bill and another long title. I think you are wasting taxpayers' money on writing such long titles. Maybe next year, with any luck, we are going to provide 4 days PL, or the year after next, we are going to give 5 days PL. So perhaps you should be more general in your style of long title drafting. And you have also said that you have no intention to restrict members' ability to move amendments to the bill. Well, they do not have the intention, but that is the objective result or consequence. So, Mr. Lee Chak-yan, maybe the legal advisor can give some independent legal advice to us. Is it that the title, the long title, means that that is the scope within which members can move amendments and nothing more? Thank you, Chairman. As said in this discussion, the drafting of the long title must comply with ROP 50(3). The basic requirement there is that the long title should use general language in expressing the main points of the bill. Well, and any amendment to the long title may bring about a chicken and egg issue, because the long title does need to state the aim of the bill. And according to ROP 57, members can move amendments. And ROP 57 says the amendments have to be related to the subject of the bill. If the President of the Legislative Council needs to make a ruling on the amendments, the long title would be an indicator, but not the only indicator. The President would have to avail himself to other provisions in the bill, and also the Legislative Council brief submitted by the Bureau and other relevant information. Objectively speaking, the President will have to make reference to the long title to understand the scope of the bill. Well, if that's the case, Chairman, that would mean that they play foul on the playing field, so that we cannot move amendments. I think they are hitting below the belt.
So this is for reference only, the long title, but it does have its impacts. If any members want to amend this ratio of 4/5 or the number of days of PL, then the long title has to be amended. It can be amended, right? But this way, it will render the long title meaningless. We might not finish our discussions on this issue today. It might require further discussion with the DOJ with the help of concrete examples. Ms. Helena Wang. In this manner, I think the government is using the long title to restrict or even strip the power of electoral members on the legislative process. We are deprived of our powers and responsibility to amend the legislation. As the government representative said, the long title should be general. But this long title is very, very specific. It stipulates the number of PL days and how the pay should be handed out, etc. And as such, legislators cannot make further amendments. The intent is very obvious. Unless the government can say that they will allow amendments. But for the 3 amendments, on top of the 3 amendments I propose, I want to introduce a 4th amendment. And I'm requesting a more general description for the long title, which is to amend the employment ordinance to provide for male employees' entitlement in respect of the birth of a child of the employee. Do I have to put it in writing? Well, you can do it later if you cannot do it now. I'll cross out the right parts and then I will give you a photocopy. Chairman, can the secretary put what I said on record? Let's invite the legal advisor to speak. On Ms. Wong, you wanted to raise an amendment. In the past, according to the past verdicts by the chairman, in general, amendments to the long title would only be accepted as subsidiary amendments to amendments of the main bill, and any amendments must only be technical in nature. So, do you mean that before the long title is amended, you would not prohibit changes raised by electoral members, right? Perhaps I can clarify things. According to the DOJ and legal advisor, this long title does not affect your privilege of amending this bill or any other bills for that matter. But I do agree with Mr. Lee Cheuk-yan. There is intent by the government to restrict the scope of amendments, but legally speaking, it is non-binding. When you amend the bill, I see that Ms. Helena Wong is trying to amend the bill to provide 7 days of PL. When this 7 days of PL is passed, the chairman, only until then would the chairman permit amendments to the long title. And perhaps after this meeting, the legal advisor can provide more advice to you on the procedural matters. Do I have to provide a written copy of the intended amendment to the long title, or can I raise an oral amendment next time? Can the legal advisor shed some light? In this amendment stage, you don't have to stipulate the amendments to the long title. Perhaps the secretary can give more on the procedural side of things. Thank you, Chairman. In the council meeting, after the CSAs are passed according to our procedures, there are corresponding changes or amendments. At that, you may raise your amendments at that time. I don't have to provide a written copy at this stage, right? Procedural-wise, we will prepare the relevant text, and depending on the circumstances, depending on which amendments are passed, we would move amended amendments. should the amendment be prepared by the secretary or the members themselves? And after resumption of the second reading of the amendment bill, after the amendments are raised by members, the committee would look at the amendments, and depending on the results of the voting, we will contact the members who raise amendments, and we would hold discussions on what kind of text we have to prepare. Any other questions regarding the long title, Mr. Kenneth Chan? Thank you, Chairman. I hope that Mr. Hurry and the administration can go back and think about this issue. There's no need to add so much details in the long title. And many, I'm sure the legislators, whether new or old, are very clear on this issue. You only have to use a simple sentence. For example, in the cases of air quality, is there a real need to be so detailed? In terms of logic, it makes things very complicated. If we have to make amendments on the long title, it's unnecessary. Let's say if some members might want to shorten the PL period to 2 days, and it might be passed, and it's a waste of resources. So why don't you respect the mechanism of LegCo and the law? So please shorten it, because it would not compromise the purpose of the legislation. It would not compromise the integrity of the legislation. So there's no need to further increase the workload of our law enforcement agencies. So can the government give more thoughts to this point? Amend. It's enough just to say amend the employment ordinance to provide for male employees' entitlement in respect of the birth of a child and of the employee. Do you need the administration to respond? I think they can go back to think about it. I think it would not. It has nothing to do with face or dignity of the administration, right, Mr. Ray Chen? We have expressed our views on the long title, but the political or objective reality is that the government is trying to limit, so to speak, the battlefield through the long title, and they do not welcome amendments. They do not want people to make amendments. And all senior officials would certainly read the long title, even if they don't read all the stipulations. So that's why the political reality is that they have spent the most efforts writing the long title. And the second reading will resume tomorrow. And it's very controversial, even though you can raise amendments. They are saying that you don't have to worry about the long title, but the reality is that we need to break a lot of barriers before we can make amendments. Mr. Martin Liao. Chairman, you are a legal practitioner, so I think you should clarify on one point. In every country, in every legislation, they have long titles and short titles for each law. The long title is very important, and the short title is just a summary. This has been a practice in all countries since the 17th century. The titles would not affect the rights to move amendments within the legislation. And the long titles would only be edited after the amendments of the stipulations are passed. Mr. Lee Chuk-yan, Ms. Helena Wong first. I just want to respond to Martin Liao. When you think about our legislations in the past, they were much shorter, and now the titles are getting longer and longer. So historically speaking, it's very simple. You just have to do some research. You just have to look at the ordinances from more than 10 years ago and compare with the legislations now. So I hope you can look at the issue from the context of history. The fact is the titles are getting longer and longer, and there is a reason in that. Ms. Helena Wong, I hope the Secretary can put on records. I strongly oppose to the abuse of power by the institutions of to come up with very long titles, and the intent is very clear. It is to restrict restrict the powers of legislators to make amendments. Legally speaking, you can make amendments. This is very clear. The microphone is off. The main problem is whether it has restricted the rights of for legislators to move amendments. The answer is no. Yes, we heard that. On the members' views, does Mr. Lam or Mr. Hui have anything to say? We've heard the members' views. I have nothing to add at the moment. If you have time, you can look at the laws of the UK in the 18th or 19th century, or our laws before 1997. Perhaps, I'm not sure if members have time. Perhaps Mr. Martin Liao has time to prepare a summary. Perhaps this is best taken up by the Secretariat. Next, we will discuss a letter from Mr. Tenkapiu, number CB 2002/13214 /01. I'll give you 3 minutes, Mr. Tang. I think it's clear from our recent meetings with the government that the actual purpose, the actual effect is that we will go back to the Labor Advisory Board this summer. Even if we don't make written amendments, we will still go back to the Labor Advisory Board, or LAB.
Therefore, I am writing this letter so that the administration can make use of the summer recess to take the initiative to clarify, or better still, amend the employee compensation arrangements. I will reiterate that the labor representatives at the LAB, in a very excruciating negotiation process, of course, employers were focusing on the number of days and the wages, but they did not spend any time on employee compensation. However, the consensus was that in terms of matters of principle, PL would be aligned with ML. And secondly, the EOC also spoke up. They said that the two should be aligned. Therefore, I don't think the administration can have the interpretation saying that the two should not be equivalent. First, can you think along the lines of non-dismissal? And secondly, at least you show some sincerity to let us know that you try to abide by the views of the LAB and the EOC, and that is, even if they leave the office or leave the work position, at least the 3-day PL pay should be given to them. So I think you should respect the EOC and the LAB. Mr. Hui, can you respond? As I said, we have heard members' views on the bill. And after the work of the Bills Committee is completed, we will make use of the summer recess to study all the views. Ms. Chen Yunhan, Chairman. Mr. Tan Kap-hill has already made it very clear. At the LAB, the number of days, etc., were discussed. And the EOC has said that PL and ML should be put on the same footing. Mr. Hui, I'm asking you to initiate some CSAs. Maybe he is unwilling, but I will reiterate, Chairman, that frontline labor representatives have had at the LAB had fierce arguments with the employer representatives at the LAB. Now, can't the administration do something according to the views of the EOC? Chairman, it would be very difficult for us to restart the argument at the LAB because, in fact, the positions are very polarized. Mr. Hui, what is your response? Mr. Hui, as I said, Chairman, we will take stock of members' views after the work of this committee is completed. I also have had the benefit of reading Mr. Lee Cheuk-yen's amendment just tabled. I think it is related to this one. Okay, any other views on this paper? Mr. Tan Kap-hill, I give you 1 more minute. Mr. Hui, I'd like to ask you the question. Is it that you are not going to give a written response to this letter before you go to LAB, or is it that you're going to respond before you go back to LAB? Mr. Hui, in fact, in May this year, we have already given a written response to employee compensation, and that's in paper bracket 2 1588/13 to 14 bracket 01. Okay, thank you. Before we go to Dr. Helena's proposed CSAs, Ms. Sitho asked a question, and that is about average daily wages and daily average of the wages. Well, actually, that paper is CB bracket 2, 1480/13 to 14 bracket 05. That is a paper issued by the Labor Department on the 8th of May 2014. The relevant paragraph is the last paragraph on page 2. Ms. Sitho, if you are unhappy with that answer, you can ask the DOJ to clarify further whether the two terms are exactly the same. Right, thank you, Chairman. It says in 15H, the provisions clearly state how the wages should be calculated in so as to take care of any misunderstanding. Now, rather than dumping the responsibility on readers of such documents, saying that they would not have a misunderstanding, why don't you go for saying in a simple way that the two terms are identical? Mr. Hui or Mr. Lam? Mr. Lam, can you or will you supplement another paper stating clearly that the two terms are identical? Well, let us read the first line. We are saying that in the new 15H, average daily wages means daily average of the wages. So I think this line goes to say that the two terms are the same. Well, what's the difficulty? If you say the two terms are identical, now in that line that you read out, you said it means, but you already said orally at this meeting that legally speaking the two terms are the same. If you can do it orally, why is it so difficult for you to do it in black and white? Mr. Lam, why don't you write us a letter? That will save your time. Okay. Next thing we have to deal with will be Dr. Helena Wang's CSAs. That's a paper submitted to members already. That's CB bracket 2, 2002/13 to 14 bracket 02. Dr. Helena Wang, I give you 3 minutes to introduce your paper. Thank you, Chairman. This paper has also been uploaded to the website, but I don't know whether you have got a copy. Well, actually, we have it. I like to take you through the paper. There are 3 amendments. Number 1, when I like to change not more than 3 days to 7 days, because I think in the first few days after discharge from hospital, the woman needs somebody to take care of herself and her baby. The DP has done a telephone interview, and most respondents said they would support 7 days. Second amendment, prior notice. I propose to delete that we should not stipulate there should be 2 more days of notice before the actual pay day after a 3-month notice period has been given. As I said, I would delete the requirement of at least 2 days prior notice. Because if it is not a cesarean operation, the father may not know that 2 days later the woman is going to deliver the baby. If that's the case, the man would not be able to witness the birth of the baby. Number 3, 15H. We have fought for the PL for a long time, and I believe the 4/5 wages should be amended to say full wages. These are the 3 amendments. From the discussion at this meeting, if the payment has been made already and in the end you have to deduct 1/5, it seems the message that has been sent out is like it amounts to a kind of a punishment. I think we should have more family-friendly policies, and employers should support employees so they can enjoy the PL and should not be subject to any financial deduction. But perhaps we need not discuss the details. Is that right? Or do we have to vote on these now? Well, I will now allow the administration to respond briefly to your proposed amendments, and I would also allow the meeting to discuss those. If your amendments are to be moved by the Bills Committee, we need to use a motion. Well, okay, Chairman. Why don't I allow the administration and members to speak before you move the motion? Mr. Hui. Thank you, Chairman. We propose 3 days PL at 4/5 wages. That is the consensus of the LAB, and this is our policy position. We stress that this is only a starting point. After the law is or has been implemented for 1 year, we will conduct a review. We agree that the starting point is a prudent and reasonable starting point. We hope family-friendly measures like these can be implemented soon. During the summer recess, we will review all the views received from these meetings and will revert to LegCo as soon as possible. Thank you. Mr. Wong Kwok Heng, you have some views to express on these CSAs? Chairman. On Dr. Helena Wong's amendments, the FTU members think that since 9 years ago we started to fight for PL, and finally the administration launched it within the civil service as a pilot, and it was then taken to the LAB. There are labor representatives from different backgrounds attending the LAB, and the LAB actually spent a few years on very difficult negotiation before the administration was willing to legislate for PL or paid PL. This is the product of a few years' power struggle between the employer and employee representatives at the LAB. Of course, 3 days PL cannot satisfy the demand of the working people, but at least it is a breakthrough. At least for the first time it is taking this step. As we said at the beginning of the Bills Committee's work, we hope that this will be given a year of implementation and the review should be conducted after that. In fact, the administration has already promised to do so. In the circumstance, if we are going to move the amendments now, and if that means the administration has to take back the bill to the LAB for further discussion, then this PL legislation will be very much delayed. We don't know how many years the LAB will again take to discuss the issue. We believe the administration should not withdraw the bill and take it back to the LAB. And also, we feel that 3 days PL can be a starting point. Labor representatives from different backgrounds at the LAB have collected views of trade unions. We think we can respect the view of the LAB and allow this to go forward. And then we can continue with fighting for better. The FTU members will not vote on whether we should move the amendments in the name of the Bills Committee. This is our stance. Thank you. Next. Tommy Zhang. Chairman, the Liberal Party respects the LAB's decisions. We will not object to the PL arrangement, but my constituents, as Mr. Wong Kwok Heng said a moment ago, think that we are opening the door maybe to more PL later on. And I won't rule out what some members would say later, that we should follow the example of Canada to provide 1 year's PL. So very simply, I won't support the bill whether it be 3 days or 30 days. I won't support the amendments, of course. If the amendment would mean a further delay of 3-5 months or 3-5 years, I wouldn't say no. I welcome Mr. Lee Cheuk-yen's proposal, but given this bureau secretary, I have no confidence in him. Maybe he would support Mr. Lee Cheuk-yen's proposed amendments, and he would take 3-5 months to discuss the issue. So I actually have no expectations of this bureau secretary that he would help the micro enterprises or SMEs. In that circumstance, I won't agree to having the CSAs moved in the name of the Bills Committee.
Ms. Ann Chang, the DAB respects the decisions of the LAB. In the last 10 years or so, from the point we began discussions, the number of days has increased from 0 to 1 to 2 and then 3. And the current level of 3 days is acceptable by most people. And at this stage, we are having to amend it again. And so we have to stop the scrutinizing process. And how much longer do we have to wait before it can be put into force? If everything goes according to plan, we will have a lot of fathers who are able to enjoy the benefit. But with a delay, we might have to wait for another year or two. I hope the members would not raise these amendments in order to pass this amendment bill on PL next year when we come back to LegCo. We can think about whether we have any amendments to make. If this bill cannot pass, the employers might be the biggest beneficiary. Businessmen like Tommy Chang will be the happiest people if we cannot pass this legislation. If you are not even giving 3 days of PL to the fathers-to-be, it's ridiculous. I think I would like to condemn Ms. N. Chang because this is pure speculation. Ms. Chang, please don't speculate on the intents of other legislators. Please just give your own views. Anything to add from Ms. Chang? We have only reached a consensus in our society after more than 10 years. If because of one person we cannot pass this legislation, are we actually helping our workers or harming them? Mr. Lee Chao-yan. Well, actually, if you talk about history, I already proposed this idea 20 years ago. I think the government is holding the legislators to ransom via this legislation. The fathers-to-be and the babies are only chess pieces for the government. I think we should have some dignity as legislators. We shouldn't accept everything put in front of us. I think what Mr. Lee Chao-yan said is disrespect. Mr. Lina Wang, it's not your turn to speak yet. Ms. Chang said, "We are the people who are delaying the enactment of this law, but the real responsibility lies in the government." With the summer coming, in the coming summer, the government has ample time to consult the LAB. The LAB's recommendation is 3 days, and there's no need for further consultation. And finally, the problem with LAB is that the formation of LAB is problematic in itself. There are representatives from chambers, but there needs to be a reform. And without a reform, the acceptability of the LAB will always be challenged, and this is a long-standing problem. Let me come back to the amendment raised by Helena Wong. Civil servants get 5 days, so the starting point of 3 days of PL is unreasonable. So I hope you don't just accept what is proposed by the government. This is only a reasonable starting point. I hope the government can consider somewhere between 3 days and 7 days. Perhaps we can think about 5 days. We hope for 7 days, but since civil servants or non-contract civil servants only get 5 days, we might be looking at an issue with public money. So I hope the presidents of LegCo can also agree with 7 days. Mr. Poon Siu-ping. I respect the amendments proposed by the members, and I also understand the recommendations of the LAB. I understand that members would like to move amendments through the LAB. But other members can, as far as I know, other members can also move amendments in after the second and third reading. facing amendments suggested by the members, would the administration revoke this legislation altogether? I would most probably revoke my abstain in the voting, but I will see how the situation develops. Let's have Mr. Martin Liao speak first. This bill was set up with the consensus from LAB. For the 3 amendment items moved by Ms. Helena Wong, they are in deviation with the from the consensus of LAB. I think this is unacceptable for the business sector because it would lead to a lot of difficulties for them. And members consist of reps from the Chinese Merchants Association, and we really have to think about whether we should stick to the consensus. I strongly oppose to Ms. Helena Wong's amendments. I agree with Mr. Lee that the LAB cannot fairly represent employers and employees, and this has been an issue for many years. Ms. Chang said that we are joining hands here. Ms. Chang doesn't seem to agree with anything. I hope she can understand the plight of the residents. But that said, Mr. Wong's amendment is not ideal as well. The best practice is to follow the practice of the top 1% of the employees in Hong Kong, which is to give 14 days. This is on our current practice. Our current suggestion is only a compromise. I hope the business sector understands that if you treat your employees well, productivity can improve, and it can only benefit your company. The government is responsible for coordinating both sides and explaining the legislation. The current suggestion cannot even align with the practice for civil servants, and it's a long, long way from the best practice used by the top 1% of the employers. They haven't answered this question. No, I don't think they would answer this question. As an international city, what kind of practices should we encourage in Hong Kong in terms of employers? I agree with Ms. Chang's amendment. I'd like to extend this meeting by a maximum of 15 members, 15 minutes. If there's no objection. You have objection. Let's vote. Do you agree with extending this meeting for at most 15 minutes? Ms. Chang, I have the right to do so. I will have another meeting on the 20th, so we can better manage all the amendments. Now I'd like to officially move the 3 amendments on the Employment Amendment Bill 2014. I accept the this motion. Mr. Tommy Chung, 2 minutes, please. I'd like to clarify one point. Just now, Ms. Emily Lau said the Liberal Party is collaborating with the Democratic Party, and Ms. Helena Wong was very unhappy with this suggestion. Because I'm so old already, I'd like to clarify that the Liberal Party is not against the idea of paternity leave because we respect the LAB, but we won't agree with any proposals of that provide more than 3 days of PL. The business sector has a lot to say on the 3 days of PL. It's not just with the issue of 3 days, but when we open the floodgates, a lot of people would be affected, and we might have 7 days or 14 days or 30 days of PL. And this is the main worry of the SMEs and restaurants. Chairman, as far as I know, I think the chairman is responsible for CSAs. I'm not sure if this is always the case. Can you clarify on this point? In the past, we adopted a majority votes approach. Well, whatever. I think as chairman, you have to use your best judgment. If some of them leave the hall, some of them agree, some oppose. I don't think it really matters who's the chairman, whether you're the chairman or Mr. Lee Chuk-yan is the chairman. Ms. Helena Wong, you have further comments? Ms. Ann Chang. Many employers are very good to their staff. Times have changed. In the current times, there's a shortage of labor these days, and most employers are doing their best. Whether we have 7 days of PL or else, I received a letter from a businessman. He's just operating a small business. If we have 7 days of PL, it places a big burden on them. After so much negotiations, we have managed to secure 3 days. So why don't we put in force first, and later on we can introduce extra days. We don't have anything else, and you are saying that we should have 7 days all of a sudden. There will be great repercussions in the business sector.
Also, Dr. Helena Wong has commented on the wages. During PL, the administration is proposing 4/5, given sick leave allowance and also maternity leave. The employers also pay 4/5 wages. So why does she want to go for full salary or wages for PL? Let us be fair. If the administration withdraws the bill and takes this back to the LAB, do we want to wait another 10 years? Let us just pass the bill quick, and then you can amend it later on. You can amend from 3 days to 4 days to 5 days. Do it step at a time. That would be easier because we don't even have the PL law. Why don't you legislate for it first? I am really speaking from my heart. All these years, my employees have regarded me as a good employer, and my Filipino maid has been with me for over 30 years. I think she might very well be the oldest maid in Hong Kong, but she doesn't want to leave me. So let us not just dwell in politics and allow it to be allow good legislation that protects labor rights to be trashed at the final stage. Ms. Helena Wong is saying that her CSAs should be moved in the name of the Bills Committee at the Council. Those in favor? We are writing down your names. Let us record the names of members who have raised their hands. I'll read them out. Chen Chi-chun, Kenneth Chan, Sit Ho, Helena Wong, Lee Cheuk-yen, and Emily Lau. Those who object to the motion, hands up. Anne Chang, Martin Liao, Tommy Zheng. Also, abstaining, Poon Shiu Ping. I will abstain from voting. I declare the motion carried. It will be the Bills Committee, or me actually, the chairman, who will be moving these amendments on behalf of Dr. Helena Wong. As I said, for the sake of fairness, I'd like to have a short meeting in July. Mr. Lee Cheuk-yen? Chairman, I can't make it in July, but either we deal with the rest of the business in these 10 minutes, or I will ask Ms. Sit Ho to take care of my concerns. Well, I don't know whether other parties or affiliations would like to propose CSAs. If you think it would not be unfair to you, then I actually don't need another meeting, because you are just moving your CSAs and you have done it in writing already. If there are more papers from the administration, then during this period, I will issue them to members for scrutiny. If members have strong views, thinking that by end July we need another meeting, please let the clerk know, or else I would, for the moment, declare that the scrutiny of the bill is completed. Tommy Zheng? Chairman, understand that we have finished clause-by-clause examination, and now one member is asking you, Chairman, to move amendments on her behalf. No matter what, this bill will come back in October or November, right? So I can't see the urgency for you to declare our work completed. Can anyone rule out moving other amendments maybe on top of those CSAs? And I won't agree to having another meeting this month. But I won't rule out having meetings in September, October before we make a decision. Well, I never said there would not be any more meetings. If we need more meetings, we should do it in July, because our memory will still be fresh. But I would ask you not to do so in July, because we don't even have council meetings and I will be out of town. So I think you should have meetings in September, October. Okay, we have heard you. Dr. Helena Wong, I have no problem having a meeting on the 21st, but I can only make it in the morning because I have 2 meetings in the afternoon. Mr. Lee Cheuk-yen, can you give me a few minutes to introduce my amendments? Okay, I'll give you 3 minutes to walk us through your amendments. Go ahead. Members, if you read my amendments, the first main amendment is to delete the words "not more than." Since, Chairman, you would be moving Dr. Helena Wong's proposal, one of which actually duplicates this one, then if in case the 7 days would be voted against, then at least we should have this amendment to say that it should not be more, not more than or up to 3 days. I think there should not be no pressure to be brought upon the employees by the employer not to exercise their rights to enjoy PL. This is the main amendment. The rest of it looks complicated, but I can explain to you that actually, with regard to sickness allowance, maternity leave, etc., I'm just seeking to apply all those to PL. The only addition is a concept, and that is the period of taking PL, because employee compensation is such that once he gives notice 3 months ahead, he is entitled to employee compensation. And I would call this period the period of taking maternity leave. In other words, starting from the day of notice till the end of the leave. Or if it is in case of miscarriage, the date of the miscarriage. So during this period, all the protection attending ML would attend to PL as well. So this is a new concept, period of taking paternity leave. The rest of it just seeks to align PL with ML except 5B. If the employee is indeed dismissed, how much money should be paid? For ML is 1 month plus 10 weeks. I'm talking about 7 days plus 3 days. And my wording is a further sum equivalent to 7 times the employee's average daily wages. This is not the same as ML. I have thought about it. It should not be 3 days every month. I think 7 days plus 3 days would be more proportional. So it is not 1 month plus 10 weeks, but 7 days extra pay plus 3 days PL pay. Now, if Dr. Helen Wang's proposals will be carried, then all the 3 days reference will become 7 days. And then I talked about unreasonable dismissal and also criminal liability. I just seek to align everything to ML. So I'm really seeking to include employee compensation in the bill. The administration, any short response? We don't have any response. In terms of employee compensation, we have stated our stance already. After receiving the CSAs, we will study them, and then we'll do so during the summer. Mr. Lee Cheuk-yen, would you like the chairman to move these amendments on your behalf? No. The rest of the members are not here. Just leave it at that. If there are other major points that will crop up, we will ask you for your availability, and there may be another meeting. As to when the resumption of second reading debate will take place, I think I have to talk to the administration. I will let you know again. Thank you very much for attending the meeting. Thank you all.